are standards and prescribed standards and specifications the same as industry standards? Or maybe you can explain the difference to us. Do you even we'll start with that.
Okay. Generally, we use US standards. However, if the equipment is procured from a non-US country, for example, Germany or Japan, and then we have to use a different standard. Not necessarily Japanese or German standards, but there are industry standards or industry practices that allow us to look at and gauge equipment from non-US countries.
In this case, it refers to prescribed standards and specifications. What does that mean? Whose prescription? Is that made clear?
I think the prescribed standards and specifications here, the specification they will provide to CUC. But you know, your earlier question about is this 3.3 monitor progress, is it reasonable? Personally, I think it's more than reasonable, because this is an IPP, an independent power producer. To let them, I mean, they're allowing CUC to look at their designs. I think it's more than reasonable. Normally, an IPP say, look, we'll just build a plant. You have no business, you just buy the power from us. You don't look at how we build our plant, what engines we select, that kind of thing. You just buy the kilowatt hours from, or the energy from us. That's what an IPP does. But I think 3.3 in the PPA, I think they're reasonable to allow CUC to review their standards and to monitor the construction.
Thank you. Thank you for that clarification. And 20 days is also reasonable for CUC to review the plans and the design.
Well, that means there's no vacation during the construction period.
Thank you. You said that this contractor is an IPP, an independent power producer. What is an IPP? How do you characterize an IPP?
Independent power producer generally is a setup whereby a developer builds a plant and sells energy to the utility or to a group of utilities. They pay for the design, they finance the cost of the plant, and a lot of times they operate and maintain the plant as well, as in this case.
An IPP does the financing, builds the plant, and sells the power or the energy to CUC. That's an IPP.
Generally, that's a description.
In this case, though, Mr. Fong, the contractor Sdllc may not be the entity that may construct or operate or be the one selling the plant. I think they will be the company that will have the contract with CUC for CUC to purchase the power. I think based on what I'm seeing here, they may outsource the actual construction of the plant, and somebody other than Sdllc may be the ones running the plant. Is that still an IPP, an independent power producer?
I would think so.
Okay, fair enough. Now I want to go back to the rates as we discussed it, specifically the contracted capacity, and I think we've already determined, based on Articles 5.3 and Section Article 6, 6.1, 6.3, that the contractor shall sell and we shall buy the contracted capacity, which, as we have figured it out, was about 50 megawatts. So just doing the math, and I don't need you to confirm this, just want to put it out. First, we have a guaranteed price that we are supposed to guarantee paying Sdllc $636,091 per month, and that would be for the capital costs. And in addition to that, we have the operations and maintenance fees, and the thing that was the lube oil. It was $1.91 for the operation and maintenance, and $1.53 for the other cost. I think that's lube oil.
Chair, it's in cents per kilowatt hour?
Yes.
1.91 cents.
1.91 cents per kilowatt hour and 1.53 cents per kilowatt hour. This is separate from the guaranteed price.
Total is 3.44 cents.
That's correct. And I'm just trying to do the math here. 3.44 cents per kilowatt hour, and you multiply that times 50 megs, and 50 megs would be 50,000 kilowatts. Is that
50 megs? If the load is 50 megawatts for 1 hour, it's 50 megawatt hours. If it's for 24 hours, you multiply by 24 hours. If it's for 30 days, you multiply by another 30 days.
How many kilowatts are 50 megawatts?
50,000 kilowatts.
Okay, 50,000 kilowatts is 50 megawatts. So 3.44 cents times 50,000, which is the kilowatt hours, times 24 hours in 1 day, times 30 days in a month, would come out to 36 million kilowatt hours. And you multiply that times 3.44 cents, it would come out to $1,238,400 a month, just based on a 30-day calculation, roughly. So this 1.2 million would be on top of the $636,091 per month for the capital costs. And if you add those two together, it comes out to about $1,874,491. Both. I'm just looking at what we will be paying per month. So just based on that rough calculation, we would be paying 1.8 million, almost 1.9 million a month. And that's aside from any other fees that we may be charged or maybe added on. I'm wondering, I want to try to compare that with our monthly costs. Now, granted, we don't use 50 megawatts every month. We may use, our current demand or load right now is anywhere from, 25 to 30, 35 megawatts. Is that correct?
That is correct.
But do we know how much our total costs? And wait a second, I just forgot something. even if you add these two costs, this doesn't even include fuel.
Fuel is a separate component.
Fuel is a separate component. And well, here lubricants is factored in. But do you know what CUC's cost is aside from fuel? Not based on 50 megawatts. Do we know how much per kilowatt hour we pay or it costs us to run our existing power plant aside from fuel? Roughly.
You referring to power plant 1 only?
What power plants are we using right now?
Well, we have a power plant in Rota and...
yeah, since this calculation is just based on the Saipan, what Saipan would be paying, so maybe you can we extrapolate what it costs us here to run our power plant other than fuel per kilowatt hour?
I don't have the exact numbers on the top of my head, but some estimates would be about 20 million kilowatt hours a month, and then you multiply by about 3.5 cents a kilowatt hour. So 20 million kilowatt hours or 20 megawatt hours multiplied by 3.5 cents a kilowatt hour.
Point of information.
Please state your point.
While you're doing your calculations based on those numbers, I just like to direct your attention to the July 4th meeting between the individuals when the former AG at Buckingham asked what we spend now per month on fuel. Mr. Fletcher answered it was about $6 million.
That's for fuel. Is that fairly accurate?
It's close. You know, the demand has been falling, especially in this time of the year. Towards December, demand is lower. But it used to be around $6 million a month and $70 million a year.
Short recess. Thank you. Yeah, you may continue, Mr. Fong.
Okay, based on current production, the capital cost for the 50 megawatt plant works out to be around 3 cents a kilowatt hour. If the plant was producing running at 50 megawatts load continuously, then the capital cost will be slightly lower than 2 cents a kilowatt hour.
Thank you for your clarification. I will yield for now to any other members. Mr. Fong, do you know if there have been any discussions at CUC regarding the disposition of power plant 1 and 2 if the CNMI decides to pursue this contract for a brand new power plant, 50 megawatt power plant? Has there been any discussion as to whether we're going to keep power plant 1 or 2 and maybe keep it for standby, or is there any discussion whether it would just be, demolished or dismantled or removed?
I recall from previous discussions was the existing site is needed for a shipyard, that the existing plant will be removed.
It would be removed to make way for the shipyard. That's your understanding?
That is my understanding, yes.
Thank you, Mr. Young. Representative Del Cruz, did you recognize?
Thank you, Chair. In line with the questioning, Mr. Young, you say that it is to be removed. Can you elaborate where is it going to be moved to? Is it going to be moved to a certain different location? Is it going to be put on eBay, for that matter?
It's possible, but the discussions that transpired was the new plant will be located not very far from the existing plant, and then the existing plant will be demolished to make way for shipyard. That's what in previous discussions. I don't know for certain if that's going to happen, but one thing I know is that the old plant belongs to CUC, and if it has to be sold, CUC is the owner, and any proceeds from the sale should be retained by CUC.
Thank you, Mr. Young. And with regards to this new PPA, how many are working in the present power plant, and power plant 1 and power plant 2? How many employees do we have?
At power plant 2, we just have 1 employee at the moment, just to watch the plant and to warm up the plant. At power plant 1, we have 80 employees. 80, yes. And that is not including employees for. We have employees there for stipulated 2. It's the stipulated order number 2. The dedicated employees for SO2, and then we have a group for the warehouse. But employees for pure power generation work is about 80 employees.
How about the power plant 4? We own that power plant now, or CUC owns that?
That is correct. That plant used to operate with 38 employees. Now we're down to 14.
14 employees.
Yes.
Are we running that power plant now to supplement power?
No, it's just a standby plant. It was relegated to standby status. We only run that plant when we have to do maintenance on our large sets at power plant 1.
Oh, okay. So it's like a backup then
Just
for repairs and so forth. What do you think is going to happen with these employees if this was privatized on this new PPA? What will be the plight of these 90-some employees?
My personal opinion is I think the new the owners of the new plant will employ a lot of the employees currently working at power plant 1, and the reasons for that is it's less expensive to do that. It's more expensive to bring in workers from the US mainland. I think if they build a new power plant, I think they will try to absorb the local workforce or the current workforce as much as possible, and I think that's a responsible thing to do.
But based on the contract that was signed in August 3rd, it doesn't speak of retaining such employees, and so do you think that maybe we really have no idea what this new company would do, whether to absorb these individuals for the operations of the new power plant? Would that be a correct assumption?
We don't know at this time what their plan is.
Mr. Young, I know that Article 3.3 was discussed earlier, but I wanted to bring your attention to Article 2.16 on page 11, and that has to do with the fuel efficiency and the cost reduction of this 50 megawatt plant. More specifically, subsection C, and let me just read that section out to you and see what your thoughts are. Subsection C states, anything in this Article 2.16, notwithstanding, failure to achieve the intended fuel efficiencies or cost reduction shall not constitute an event of default, and neither party shall have the right to terminate this agreement as a result thereof. My take on this provision here is that if at some point, maybe after a year or two of this new power plant operating, and it fails to meet that 10% or more efficiency as compared to power plant 1 that we have right now, basically what it's saying is that nothing will happen if it doesn't continue to be efficient, and that the company will not be in default. What is your thought on this provision, Mr. Young?
You know, I think if there's an opportunity to build a new plant, then the efficiency is should be a minimum of 10% or better, and the PPA agreement should reflect that, and there should be penalties. The typical practice, if there should be penalties if you don't meet that efficiency. Otherwise, the question will be raised: why build a new plant in the first place if it can't do better than the old plant? I mean, it's common sense, I think.
I totally agree with you, Mr. Young. You know, someone once said that even though we don't get the efficiency, we're still getting a new plant, but what does that mean? Is, if we're not going to get a new plant with the efficiency, then what's the point of having a new plant for the sake of having a new plant? Would you agree?
Yes, I agree. But if I can mention this, the cost of a plant is nowhere near the amount of fuel that goes through that plant. The amount of fuel that goes through a diesel power plant is 20-30 times the cost of the plant. In fact, earlier this year I ran some numbers. I wanted to do a projection on how much it will cost the CNMI in diesel cost for the next 20 years. I mean, we power plant people, we do this all the time. We want to know what our real costs are, and I ran the numbers based on historical data for the last 6 years. And the fuel, the average increase in fuel costs or diesel costs per year in the last 6 years was about 5.5%. But when we ran the numbers, it will cost the CNMI $2.25 billion over the next 20 years. Now, that $2.25 billion doesn't stay here; it goes outside. Now, it's not my call. There's somebody who has to make the decision, do we really need to go with a diesel plant? $2.25 billion over the next 20 years, not 25 years, 20 years. But the cost of a new plant is only $200 million. So if you run the numbers, it's what, over 20 times higher. That's normal for diesel power plant. Very normal.
Lastly, Mr. Young, I recall we went to San Diego together with the former executive director, Mr. Malay, and upon our return, we submitted a statement report from the three of us to the governor. Do you know if that report was ever read by the governor, or did you have discussions after that with regards to that report, Mr. Young?
I don't know where that report went and how far it went, and I haven't revisited the subject for quite a while, so I don't recall or I don't know what's going on.
I understand, and I'm just as a part of not knowing what was going on as yourself, because when we submitted that report, this project was actually already in the burner, being negotiated. So all I can say is at least we had something to give to the governor for his perusal, if you will, and looking over the different options that the CNMI might have. Unfortunately, a PPA was signed, and it had to do with the type of technology that we already have here. So I just wanted to see whether you had heard of anything from the administration or the acting executive director. Thank you, Mr. Young.
Thank you, Representative. It's almost 12 o'clock. We do have 1 o'clock hearings. This question and answer period has lasted about 2.5 hours. Are there any further comments before we break for lunch? If I may, just one very short one, not necessarily to Mr. Fong, but to the legal counsel. Ms. Fisher, have you reviewed the contract prior to its signature? As CUC's legal counsel? Just a yes or no.
I looked at it, and Sometime in July.
Did you give any legal advice to CUC before its signature?
I gave a very preliminary look at it, and I did make some comments to CUC about it, but that was all.
I'm going to raise one small provision of the contract and see if that was one that you did look at and whether you did provide comments. It has to do with a provision regarding hazardous and toxic conditions. It's on page 8 under Article 2.5. And without reading it, it's basically states that if the contractor encounters subsurface, meaning below the ground, pre-existing hazardous materials during construction, they shall take, first they shall provide written notice to CUC and try to minimize the consequences to this project schedule in dealing with such conditions. Further goes on to say that they shall not be responsible for or have any obligations pursuant to the agreement or otherwise with respect to the removal, handling, transportation, disposal of any pre-existing hazardous material or other pre-existing hazardous, unsafe, or unhealthy or environmentally unsound condition on site. Upon written notice from the contractor to CUC of the presence of these materials, CUC shall promptly determine and arrange for the necessary environmental remediation with the cost of such remediation for the account of CUC. This basically means that if the contractor finds hazardous materials, CUC would bear the cost of any remediation or any mitigative work that may be required. And we do have environmental laws and regulations in place to address such an event. Do you know where the new power plant will be situated, Ms. Fisher?
Chair, with all due respect, I don't feel it's appropriate in the public forum for me to answer questions that could impact on our litigation in Maritita versus Video currently. I have an attorney-client privilege, and I'm invoking it regarding my comments to the client for right now.
So any question we ask is you'd be...
Chair, I wasn't called here to testify today, and if you're going to ask me about legal comments or suggestions I made to my client, at this time with other litigation pending, I think I've explained this to the committee, respectfully, you know, CUC wants to provide you with any questions and answers that you'd like, but we don't want it to affect our litigation.
Okay, well let me just, I won't ask you the question, but I will inform you, since you may want to take note, that the site, the proposed site for the new power plant was the former site of the Department of Public Works Central Office, and we have heavy equipment and probably diesel spills and all kinds of other spills, lube oil, in that area. Everybody, that's general knowledge. And on top of that, what may not be common knowledge is that that was a former U.S. military site. And I think any basic background check would clarify that or would prove that. And what's even more non-common knowledge is before it was a U.S. military defense site, it was a pre-war Japanese military defense site. So we have at least 2 military use of that area, and the CNMI government's use of that area for public works. So knowing that, we can expect that there will be pre-existing and on more than one subsurface level contaminants in the area. And so I wanted to find out, because now the cost of mitigating this potential adverse effect or hazardous and toxic conditions is going to be borne by the CNMI, CUC in particular. And that should be considered, because if there's a decision to build this new power plant there, that would cost us more. And if you weigh that and look at the basis for building this new power plant, the basis is because it would be a shipyard. There would be a shipyard area at our existing power plant. And we don't even know or have any guarantee whether a shipyard will be built. So we have to kind of weigh a lot of things, and even something as small as this section of the contract should be put together in our evaluation of this proposed project. I just wanted to make that clear for the council and Mr. Young for their knowledge, I guess. Thank you. And if there's no further, there is one small one. Representative Sablan, you shall have the last say.
Thank you, Chairman. Very quick. At the phone earlier when I asked you whether in whose best interest is it to operate a 50 megawatt plant at full capacity continuously, you answered that it was the best interest of the power plant owner. Summation. I don't know whether that was the reason, but because of profit considerations. Is it also in the best interest of the customer in this situation for Sappan Development BPA, CUC and its customers? Is it in the best interest of CUC and its customers to operate a plant in that manner? Or require the customer in this manner or this situation, CUC and its consumers?
Press the mic.
Can I repeat that? I can speak for the customer because I'm a customer myself. When I talk about best interest, if something is in my best interest, that means it's the lowest possible price. I mean, price is good and reliability. So those are maybe unknowns at this time, although we have some indication. But we don't know what the new engine efficiency is going to be. If the engine efficiency is going to be same as it is now at power plant 1, then because of the capital cost, the cost of electricity will be higher. However, if it's more efficient, then and how much by, maybe there's some benefit for the customers in the end.
But as hoped for in the agreement where CUC is required to pay for the operation of a 50 megawatt power plant at base load continuously when demand is only at 30 megawatts.
I think that has got to be worked out. It's not clear right now to a lot of us, but something will have to be worked out if the load remains at 30 megawatts and we are required to pay the cost of a 50 megawatt production. Something has got to be worked out. It's not clear.
Okay, so if we are required to pay for 50 megawatt production where the demand is only 30 megawatt, is that in the best interest of the consumer?
Well, if I can put it this way, if you going to buy 10 loaves of bread, but the shopkeeper charges you the price of 15 loaves of bread. I mean, I think everyone can conclude for himself if it's in the best interest of him or customers in general.
So it will not be in the best interest of the customer to be paying for something more than what you actually need.
Yeah, you know, the term in best interest is a little under the circumstances right now. It's a little bit.
Well, let me rephrase it. Let's substitute the word best interest and say that operating scenario, would it result in a lower rate for the consumer or a higher rate, knowing that you're paying for more than what you actually need?
Well, if the load remains at 30 megawatts or thereabout, and we are required to pay a production of a 50 megawatt capacity, well, the rate is going to go up, not down. But I believe something will be worked out, because it's not a practical thing to. You don't sell something and charge customers at the price of something else. You sell something and based on the price of that item alone, or those that energy production alone, or sales.
Thank you.
Okay. Thank you.
Thank you. Mr. Wallon, Young Fong, you know, you said something very interesting, is that that's an issue that has to be worked out. And I think I agree with you. I totally agree with you. I guess a question that can be asked is, can it be worked out? And I'd like to ask the legal counsel a general question at this point of time, where the contract stands. Can that be worked out?
Chair, I can tell you as a general matter with contracts.
Just as a general matter.
As a general matter with contracts, once you have an executed contract, which is a legal document, the parties are bound to that contract, absent some reason why that contract would be void or illegal or have other problems. But assuming it's a legal contract, the parties then become bound to it. And unless there's been another problem or a mistake or other reasons why we can rescind a contract, or we would ask to, we would have a contract that everyone's agreed to and bound to. And the only other way to change it would be if both parties came together again and made a subsequent agreement to modify that contract. That's my understanding of it. I know you have House Legal Counsel. Hopefully I got it right, guys.
Well said, Counsel. I think, you know, in clarifying the issue in relation to other contracts, you're basically stating that this contract is an executed contract. And for that to happen, can it be worked out, would depend on both parties agreeing to come back to the table and renegotiating. Is that a fair statement, Counsel?
In that statement is the assumption that it's valid and executed, any contract, and that would then be correct.
Thank you. Thank you. With that, we are going to break for lunch. We will dismiss Mr. Wallon Young for now. Mr. Fong, I'm sorry. If the committee so decides that you need to return to answer any further questions, we will give you reasonable notice. You will probably not be subpoenaed again, but you are dismissed, not excused. So the committee can and may ask you to come back to answer further questions. So with that, for now, you are dismissed, and I ask that you please provide your point of contact to our Sergeant at Arms, who is next to me. I don't anticipate you coming back, but in the event the committee so chooses, we can. With that, good afternoon, sir. Have a nice day. And Deb, thank you also.
Thank you, Chair.
Thank you.
This committee is dismissed until 1 o'clock.